I'm making two, affirmative defenses of various facts, evidence that's outside the charges. The first is the statutory administrative remedy is not exhausted, which I will develop in a moment. The second is the charging instrument is invalid. It contains intrinsic fraud and forgery. There is a quote from the Tennessee court, and it is called Tennessee Enamel Manufacturing Company versus Hague. And it puts in a nutshell the administrative remedies needing to be exhausted before the court has jurisdiction over contested cases concerning the licensing, revocation, and suspension.
May I ask where you're?
I will read this, sir.
May I ask what page you're on your argument?
No, I'm on page 2, but what I'm reading is from something that I'm reading in support of what I'm going to say here next.
What was that case?
This case is Tennessee Enamel Manufacturing Company versus Hague, H-A-K-E.
A civil case?
183 Tennessee, 615 at 620. 194 Southwest 2nd, 468 at 470. It says it's citing a number of different things here.
All right, go ahead.
Okay, what it says here is we recognize the general rule that where an administrative remedy is provided by statute, relief must be sought by exhausting this remedy before the courts will act. So whenever there is a contested case concerning licensing, the jurisdiction first is with the Department of Safety, Nashville. They have been given the authority to write all the rules and regulations, and they also will administer any contested cases under the Uniform Administrative Procedures Act, Title 4, Section 5. Driving is a privilege. Privileges are heard first, in the first instance, at the administrative level. Privileges of driving, and the legislature determining what is a privileged taxable activity is found generally under the Constitution of Tennessee, Article 2, Section 28. Also TCA Title 55, Chapter 50. Whenever there is a contested case, the hearing is to be done by the Department of Safety and Homeland Security before a commissioner or designated hearing officer with the judicial review. And where that can be found is in my motion, you can see there. Tennessee law recognizes that licensing questions tied to the use of the public highway and commerce are administrative in nature. A number of cases which address this administrative hearing. One is McMinnville Freight Line Inc. versus Atkins. 514 Southwest 2nd to 725, where it says that the question of whether or not there should be a refusal to the license and there's some dispute, that it was to be done purely administratively. Another case is the Hoover case. This is Hoover Motor Express, and it states virtually the same thing.
Is that a Tennessee case or is that a federal case?
Just a moment, sir.
What's the side on
Okay, just a second, I'll get here for you. Hoover Motor Express Company versus Railroad and Public Utility Commission, 195 Tennessee 593 at 616. 261 Southwest 2nd, 233 at 243.